All right. I just started the live streaming so that it's available to the public. And we also record it to the cloud. So, and the other question I had is, are either one of you invoking the rule?
I'm not. I would certainly don't object to it, but I don't think it's necessary given that our two witnesses are officers of the court.
I would agree with that, Your Honor. And I just have one logistical question for you as well.
Sure.
I've noticed that the screen sharing has been disabled for us. There are several documents that have been stipulated to and are part of just the packet that I might want to share at various times, particularly during cross-examination or argument. How would I go about doing that?
That's a very good question. How many documents, how many?
There's probably 10 altogether that I might want to choose from.
I will tell you, we have looked at the record. If the only thing I can think of is if you ensure that you give us the exact reference, I mean, we can look at it. I've got all 300 pages here next to me. And I know that the other judges also have had an opportunity to, I don't know if everybody printed them out like I did, but that's the only thing I can think of. I don't.
Okay. That's fine.
Yeah, just as long as you know, a lot of the documents I know that we've looked at, and so when you're referring to them, if it's somebody's affidavit or the testimony of Judge Richter or whatever the case may be, we're pretty familiar with it, or the order of contempt, etc. So
okay, fair enough.
I feel fairly confident. I don't think you're going to need that, but at any rate, anything else?
I don't, not from examiners, Your Honor.
No, Your Honor.
All right, terrific. Thank you, gentlemen. I appreciate it. Let me let in the witnesses. I'll have Ms. Jenks swear in the witnesses. And here comes Judge Richter. All right, everybody's connecting. Good morning, gentlemen.
Good morning, Judge.
Good morning, Judge.
And I think Judge Richter is just connecting. There he is. Good morning, Judge Richter. I think you're on mute. That's all right. All right. We're going to have Ms. Jenks swear in the witnesses. Mr. Pinnell, my understanding is that you will not be called as a witness today, so you don't have to participate in the Zoom. We are live streaming on the 8th Court of Appeals YouTube channel, so you're more than welcome to view it from there. But we're going to swear in. My understanding is the only two witnesses that are going to be called are Mr. Kubosh and Judge Richter.
Okay, Judge, the only thing I would say is if Mr. Kubosh is called to testify, I should be present to the extent any of the testimony seeks privileged information so I can give him the appropriate instructions.
That's fine. I didn't know if you wanted to participate for that reason. I don't have any problem with that. And he is, my understanding, based on the representations of the examiner, Mr. Rourke, is that he will be called as a witness. So hopefully y'all have a way that you can object if you think it's the question or the answer calls for privileged information.
Thank you, Judge. Yes,
you would object. All right. Judge Richter, Mr. Kaposh, if you don't mind, Ms. Jenks is going to go ahead and swear you in at this time.
Good morning. I guess raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Excellent.
Thank you. Thank you, gentlemen. And so will you call court for us, Ms. Jenks?
The Honorable Special Court of Review is now in session.
Thank you. And at this time, we are in the case number SCR 20-006, Honorable Robert Richter. All right, and you may proceed, Mr. Graham.
Thank you, Your Honor. Good morning, Your Honors. May it please the court, counsel, Judge Richter. Good morning. I'm Michael Graham on behalf of the examiners. I am the general counsel for the State Commission on Judicial Conduct. Before beginning, I'd like to thank each of the panelists for their service on this court of review. The panelists are drawn by lot by the Chief Justice of the Supreme Court, but they've each volunteered for that potential assignment, and it comes on top of their normal everyday duties as a Chief Justice and justices of Texas Courts of Appeals. So on behalf of the commission, we thank you for your service in this court of review. It's important work in maintaining the public's confidence in the judiciary, and I think as well as the judiciary's confidence in itself. Just a quick bit of background. The State Commission on Judicial Conduct is a constitutional agency, part of the judicial branch, that along with occasionally courts of review like this, administers judicial discipline in the state of Texas. For the most part, with some exceptions that aren't really relevant here, the commission and courts of review such as this are the bodies that speak to the judiciary and the public regarding the ethical standards members of the Texas judiciary are expected to and must uphold. And I think it's important also to note the purpose of judicial discipline is not necessarily to punish, but more importantly, to maintain the honor and dignity of the judiciary and to help ensure public confidence in the administration of justice. In matters of judicial discipline, accepting suspensions, removals, and resignations, which are not implicated at all in this matter, the commission and this court of review are given the authority to issue sanctions, public or private, to judges for improper conduct. From the bottom up, those sanctions are private admonition, private warning, private reprimand, public admonition, public warning, and public reprimand. Additionally, judges can be given orders of additional education, again, public or private, when appropriate, and those orders can be independent of or paired with any of the sanctions I just described. In the instant case, after conducting an investigation into the underlying complaint, the commission determined the evidence demonstrated Judge Richter failed to accord attorney Paul Kubosh with appropriate due process of law with respect to contempt proceedings before him, including the improper issuance of an arrest warrant against Mr. Kubosh. Ultimately, the commission issued the lowest level of public sanction available against Judge Richter, a public admonition, along with an order of additional education requiring the judge to obtain 2 hours of judicial education in the area of proper use of contempt proceedings. Examiners believe the evidence presented here today, in relevant part undisputed and stipulated to, demonstrates Judge Richter, 1, failed to comply with the law with respect to the contempt proceedings involving Mr. Kubosh in violation of Canon 2A of the Code of Judicial Conduct. 2, failed to maintain professional competence in the law with respect to those proceedings in violation of Canon 3B2. 3, failed to accord Mr. Kubosh the right to be heard according to law with respect to those proceedings in violation of Canon 3B8. And 4, engaged in conduct that was clearly inconsistent with the proper performance of his duties with respect to those proceedings in violation of Texas Constitution, Article 5, Section 1A, 6A. Examiners offer, having seen that the evidence presented in fact demonstrates those failures, this court should then, at the very least, affirm Judge Richter's public admonition and order of education. Before I wrap up, I'd like to make a couple comments regarding what this case is not about. This case is not about whether Judge Richter, or any judge for that matter, could follow proper procedure and ultimately make the discretionary ruling that a litigant, witness, citizen, or officer of the court acted contemptuously. Neither is this case a referendum on Judge Richter as a human being or even as a judge. Judge Richter has served on the bench for a number of years, and the commission has confidence he can continue to so serve. We're here to address a specific set of behaviors and conduct that the commission deems sanctionable, and we think this court will ultimately agree. Thank you.
All right. Mr. Rohr?
Thank you, Your Honors, and good morning. And Mr. Graham, thank you for your professionalism and ease in which you've been able to work these past few weeks. So you might be thinking, why are we here for a simple public admonition? They're not trying to remove him from the bench or anything like that. I would ask you, though, yourselves, the justices that are taking part in this process, how you would feel if you thought you had been publicly admonished in a way that you thought was unjust. And I'll tell you, Mr. Richter, definitely, Judge Richter feels that way after being a judge for 32 years. And we are here on that principle. We do not think that the commission has authority under this set of facts to admonish him in any way whatsoever, private or publicly, quite frankly. And I think it's also a chance for you to better clarify what errors rise to the level that can be sanctionable. So a brief recitation of the facts here. And by the way, the three items that they are claiming that Judge Richter failed at was failing to personally serve Kubosh with a show cause notice, signing an order finding him in contempt, and issuing an arrest warrant. What they failed to even plead were necessary elements of the offense of making a judicial error or a legal error, which is bad faith. They have pled nothing about that. If you allow this to go through, then what you're allowing is a normal legal error to become sanctionable, which means that every error that a judge makes that you are looking upon as your role as appellate judges could be sanctionable. This cannot be the law. But a brief recitation of facts, how we got here. Judge Richter's been a judge for 32 years. He's had 3 contempt hearings during that time, or 3 contempt processes. He's not someone that's willy-nilly throwing around contempt. One of those individuals happened to be Mr. Kubosh in 2006, 15 years ago. What the facts giving rise to this particular occasion were, there was an individual who got some traffic tickets over 4 years now. He showed up for his first, they're in Missouri City. He showed up for his first pretrial setting and set the cases for trial. He failed to show up for trial. Warrants were issued for his arrest, which is perfectly acceptable to do and what happens in municipal courts all across the state when defendants fail to show up. He then hired Mr. Kubosh. Mr. Kubosh files letters of representation, and those warrants are withdrawn. Those cases are set for a pretrial hearing, and both the defendant and Mr. Kubosh fail to appear. He's not found in contempt at that point, despite the failure to appear. The cases are ultimately set for a preferential trial setting 4 months down the road. They're set in October for a February 15th preferential jury trial setting. In Missouri City, the court settings state that motions for continuance are to be submitted at least 8 days prior to trial. One day on Valentine's Day of 2018, Mr. Kubosh files a motion saying that the day before the preferential jury setting, saying that he has too many courts and too few lawyers to show up for the preferential jury trial setting the next day. That motion is heard by another judge, not Judge Richter, another judge in the Missouri City Court, and it is denied. The next day, the defendant shows up. Judge Richter asks that defendant, "Have you heard from your lawyer?" The man says no. There's apparently a phone call made to the clerk from someone at Mr. Kubosh's office that does not identify herself, but says that she had the flu and that she couldn't make it. This person had not been previously identified, and of course, the flu issue had not been brought up in the motion the previous day. So everyone sits around till noon. Judge Richter eventually lets the individual go, the defendant, and resets the case to another day and proceeds to issue 2 different orders: a show cause order to Mr. Kubosh, asking him to explain why he should not be found in contempt for not showing up for court. And he also issued an order of contempt. And I don't know if y'all are familiar with, I'm guessing you are, contempt law, but I'll submit that it is confusing. And there are plenty of cases out there to demonstrate how confusing it is, whether it's direct contempt or indirect contempt and what rules have to be followed after that. We made a little chart that I'll include with the follow-up submissions in writing, but it is a confusing area. If it's direct contempt, basically you have to issue an order of contempt originally and assess some type of punishment for it to be sent on to a different judge. If it's indirect contempt, you're supposed to just issue a show cause motion. Judge Richter issued both of those, but the contempt motion was essentially conditioned upon the show cause. That show cause hearing date was faxed to Mr. Kubosh's office, as was every single notice that that office received from Missouri City. Everything was faxed. That hearing was supposed to take place on March 15th. I'm sorry, March the 1st. 2 weeks later. Nobody showed up for that. That day, Judge Richter did a couple of things. He finalized the contempt order, and he also issued a warrant for Mr. Kubosh's arrest. I believe actually that was the 8th of March, so I apologize if I get the date wrong. It was an error for him not to personally serve Mr. Kubosh with notice of the show cause hearing. But it is also an error that, as case law will explain, can be cured, and in fact was cured in this case. Furthermore, what Judge Richter did was simply file the wrong vehicle for ensuring Mr. Kubosh's attendance. He filed a warrant. I know, Judge Rodriguez, you have experience in criminal law, but for the other 2 justices, when someone doesn't show up for court all day, every day in Texas, across the state, at least prior to COVID, the vehicle for arresting someone when they don't show up is a capias. Judge Richter, I believe, could have issued a capias, which would not require, of course, any kind of affidavit. He issued a warrant instead. Those two vehicles for having someone show up essentially result in the same thing, which is someone being arrested and brought to court. Mr. Kubosh claims that he did not receive the notice of or the show cause order by fax, but there is a fax confirmation sheet, which you will see in the exhibits. And the warrant of arrest, or notice that there was arrest warrant, was also faxed to the same fax number with the same fax confirmation. Mr. Kubosh did receive that. We know that because a lawyer from his office showed up that very day. And so we know he received that. He talked to a clerk. Judge Richter was not there that day. And long story short, he was asked to show back up on the 13th. Mr. Kubosh had a pre-planned vacation that day. Another lawyer, Mr. Purnell, showed up about 18 days later, asked Judge Richter to withdraw the warrant and withdraw the finding of contempt, both of which were granted, and it was sent off to another judge. Mr. Kubosh was then given plenty of notice about what the allegations for contempt were for the de novo hearing of the contempt, which was to take place in front of another judge, very much like the de novo hearing we're having today. Case law will tell you that the notice for that de novo hearing cured any lack of notice that he received for the prior hearing, for which the notice was served by fax instead of personally. It cured it. Mr. Kubosh, if that hearing had taken place, could have been legally found in contempt at that subsequent de novo hearing. That is the short recitation of the facts. And what you are left with is what to do with those, what I'll refer to. Thank you, Ms. Jinks. Is that how much time I have left? Thank you. What to do with those technical errors that Judge Richter made in getting to where he did. The three things that I mentioned earlier. Failing to personally serve Kubosh with a show cause notice. He's going to say that he did that. He did not personally serve him. He served him by fax. He's going to tell you that he did that because that's the way all the notices were served to Mr. Kubosh and, quite frankly, all the other lawyers that showed up in that court. And the fact that someone has to be personally served for notice on a show cause hearing is case law. It's not in a statute. It's not something that, in my opinion, is completely obvious. The second thing is that he signed and finding him in contempt before the show cause hearing was had. He certainly did that as well after Mr. Kubosh failed to appear for the show cause hearing. He subsequently withdrew that, though, which resolves that error, and issued an arrest warrant without a sworn complaint or affidavit. He did that as well. And I would argue, though, that he could have legally issued a capias or a writ of attachment, which serves the same purpose as a warrant. They all accomplish the same thing. And regardless, Mr. Kubosh was, of course, never arrested. And I failed to mention this earlier, but the warrant was never actually entered into the system. So it was never an active warrant from that perspective. And in fact, Mr. Kubosh apparently went on a vacation at some point. So I guess he wasn't worried too much about getting arrested. Regardless, that was withdrawn at some, 3 weeks later, essentially 18 days after the fact. He was never arrested. And the subsequent notice to Mr. Kubosh for the de novo hearing cured any of those errors. And so the question becomes, for a legal error to rise to the level of judicial misconduct, or let me back up. when determining whether legal error rises to the level of judicial misconduct, the test cannot be whether the judge intended to engage in the conduct. Mr. Graham in his brief has suggested that if you intend to do it, then it's a violation. That cannot be the case. If that were the case, every ruling that y'all look upon every day in your jobs as appeals judges that you find to be an error would be something that the Judicial Conduct Commission could sanction someone for. That cannot be the case. I've also left out another very important fact, and I keep forgetting this, and it should have been the first page of my brief. Judge Richter actually called the Judicial Conduct Commission the day after he issued that warrant for Mr. Kubosh, thank you, Ms. Jinks, and asked Joseph Unruh, who's a lawyer, used to be a lawyer with the commission, this is what's happened. Is there anything else I need to do? Mr. Unruh told him,
Your Honor, I'm going to have to object to that statement as hearsay. And if I need to call Mr. Unruh as a rebuttal witness, I'm prepared to do that.
Judge, Mr. Richter, and this is in the record. He mentioned this in his very first response to the commission. It's never been rebutted by the commission. It's never come up at the informal hearing. Not once before today have they tried to dispute that this occurred. You're on mute,
Chief Justice.
Judge.
The perennial mute problem. I think the stipulated record speaks for itself. And if I remember correctly, thank you, Ms. Jinks. If I remember correctly, I think that Judge Richter refers to that both in his, at least in his testimony. Yes. So.
To wrap up, Judge, if I can have 10 seconds.
Sure.
How could the commission find a judge, find his errors sanctionable if A, the errors by law are cured as far as the actual procedures are concerned? In other words, the errors were not deficient enough to eventually not be able to hold Mr. Kubosh in error. And secondly, if he actually called the commission to ask if he was doing things the right way and they said, yes, you are. I don't think that's fair. And we are asking that you find the same.
Thank you. Mr. Graham, you want to call your first witness?
Yes, Your Honor. The examiner's called Judge Robert Richter.
You may proceed.
Thank you, Your Honor. And Judge Richter, I'm going to try to refer to you always as Judge Richter to avoid confusing you, myself, the court reporter, or the other panelists as to which judge I'm speaking to. If I confuse you, please let me know. You've served as both an associate judge and the presiding judge for the Missouri City Municipal Court, correct?
Yes, sir.
And Mr. Rohr alluded to this in his opening. I think he said you've served 32 years. Is that correct?
Yes, sir.
Have you sat any other benches besides the Municipal Court of Missouri City?
Yes, sir.
What benches are those, Judge Richter?
In the city of Stafford as an associate judge, and in the city of Simonton as a judge.
Okay. Thank you, Judge. You're also licensed to practice law in the state of Texas. Is that correct?
Yes, sir.
How long have you been an attorney in Texas, Your Honor?
Since September of 1971.
Okay, thank you. I want to jump right to it. I want to talk, really just ask you a couple questions about the show cause order and contempt order that you issued on February 15th of 2018 in the underlying proceeding. You're familiar with those orders, correct?
Yes, sir.
Do you have those orders where you can look at them, Judge Richter?
Well, let me see. I believe I do, sir, but let me.
Sure.
Okay,
Take a
make
second.
sure.
And I don't know that it'll be necessary, but just in
Well,
case.
It's okay. I think I have them in your charging document. You have copies of them. Yes, sir. I'm looking at the show.
You have the one
Cause.
that's labeled contempt show cause and the
And
one that's labeled order of contempt, correct?
yes, sir, I have both of those right in front of me.
Okay. The first question I want to ask you is the document labeled contempt show cause order references an attached order. That's the order of contempt, correct?
Yes, sir.
Okay. And in that contempt show cause order, it says, amongst other things, if Mr. Kubash fails to appear at the show cause, you'll make the attached order, which is the order of contempt, final, correct?
Yes, sir.
Okay. So when you look at the order of contempt, that order's signed by you, correct?
Yes, sir.
And it's dated February 15th, 2018, correct?
Yes, sir.
So what else did you consider needed to be done to make that a final order?
Well, sir, as I understood the procedure, and apparently that's the problem, I thought I had to enter an order and then set it for show cause. That's what I thought I was supposed to do.
The order of contempt also references a previous contempt issue with Mr. Kubash from 2006, correct?
Yes, sir.
And we also have that prior order in the record. I don't know if you remember it, but I guess I want to ask you, what happened at that time was Mr. Kubash allegedly failed to appear for a hearing at some time in 2006, correct?
Yes, sir.
And did you treat it the same way as you treated this one? And what I mean is, did you issue an order of contempt and a show cause order the day that Mr. Kubash allegedly failed to appear for that hearing?
I think so.
Okay.
I'm sorry, I can't remember exactly, but I think so.
Okay. And again, the record will speak for itself, but I wanted to see what you remembered about that. Is there any reason for you to doubt that's how you handled it?
I don't think so.
Okay. Those weren't the only times that you handled an attorney contempt in that fashion, are they?
Yes, sir, they are.
Well, let me refer you to one other thing that's in the record. It relates to an attorney named Kirby Taylor.
Yes, sir.
And it's the same sort of a situation. In the record, we have an order of contempt issued in December of 2014 against you, or against Mr. Taylor by you. And does that help refresh your memory about what happened with Mr. Taylor?
Well, I may not have understood your question, sir. I provided the order where I held Mr. Taylor in contempt. So
Okay.
if that's what you're referring to, yes, I did, but
Well, and what I'm getting at is that you handled it the same way, didn't you? I mean, what happened was Mr. Taylor failed to appear on December 18th of 2014. And so that day you issued an order of contempt against him related to that, correct?
if the record reflects that, that is the date, sir. I don't recall the exact date from 7 years ago, but that sounds approximately correct.
I understand, Judge, and I'll represent that's what the order says.
Right.
So let me ask you this. In each of the contempt orders we've discussed, in the opening paragraph of those contempt orders, you expressly reference Government Code Section 21.002 as your authority for contempt, correct?
That is my understanding, yes, sir.
But doesn't Government Code Section 21.002D give an alleged attorney contemner an unqualified right to have the contempt matter heard by an independent judge?
If they request it, yes, sir.
So in your opinion, is it proper to issue an order of contempt in that context for you as the initial judge?
I thought so at the time, yes, sir.
Okay. I want to talk just a little bit about the arrest warrant that you issued in this case. The underlying case, I mean.
Yes, sir.
The arrest warrant states, and I got to look at it really quick. that it was supported by a written complaint under oath and filed before you, correct?
That is what it says. Yes, sir.
Why would it say that?
Because that's the form that comes in the Encode software that most courts use. And that's the language that's in it. And I simply didn't realize that language was there, sir, referring to a complaint.
Okay. But there wasn't a written complaint under oath associated with that arrest warrant, correct?
That is correct, sir.
Okay. Why'd you issue an arrest warrant as opposed to a show cause order or an attachment, or even, as Mr. Roark referred to, potentially a capias?
I thought it was what we had to issue, sir, to try to get Mr. Kubash's attention about not coming to court.
All right. I think that's all I have for for Judge Richter at this time, Your Honor. I'll pass.
Mr. Roark?
Thank you. Thank you. Judge Richter, you've been a judge for 32 years, is that correct?
Yes, sir.
And in those 32 years, how many times have you initiated a proceeding to find someone in contempt?
So far as I remember, sir, only the 3 times that have been referenced today.
Okay. And when, let's go back to the one that Mr. Graham brought up with Mr. Kubash originally back in 2004 or 6, I'm sorry.
6.
You issued the show cause hearing, he showed up, and you ended up actually dismissing that, correct?
Yes, sir.
Okay, so you issued the show cause, but you did not formally find him in contempt, correct?
That is correct, sir.
And why did you do that?
Because he appeared, sir, with his attorneys, and he assured me he would be in court.
Okay. And do you think that you followed the proper procedure in that particular case?
I thought I had, sir.
Okay. And with Mr. Taylor, did you ended up finding him in contempt?
Yes, sir. And he came in and paid his fine of $100.
Okay. Explain what was, well, with this last order of attempt proceeding with Mr. Kubash. We've been talking a little bit about that in a vacuum, but what was going on? Can you please explain the context of what was going on with his office at the time that made you think this was important?
Yes, sir. Not Mr. Kubash himself, because he never came to our court, but different members of his firm would come to the court. And if not, he had a number of other independent attorneys that would often come to the court. But there had been a number of instances where no one had appeared after jury trial settings had been requested. And I think that when the motion for continuance filed the day before the jury trial setting of February 15th, it just was too much.
Okay.
When he didn't show up.
And so what was your purpose in doing what you did?
To try to get him to come to court or get somebody there to represent the clients that for whom they had requested jury sittings.
And if he had walked in your office subsequent to this and said, Judge Richter, sorry about the other day, I'll do better, what would you have done?
the whole thing would have been dismissed.
And that's similar to what happened the first go around back in 2006. Is that correct?
Yes, sir.
Let's talk specifically about some of the issues that Mr. Graham brought up. The first thing they've charged you with is failing to personally serve Mr. Kubosh with a show cause order. Was it intuitive to you that that order had to be served personally?
Not at all.
How are court settings and anything else served in Missouri City Municipal Court?
When requested by fax, they are served by fax. When requested by email, they're returned by email.
How had they always been requested by Mr. Kubosh's office?
So far as I know, sir, by fax.
Okay, so as far as you're concerned or no, all communications with Missouri City and Mr. Kubosh's office are by fax, is that correct?
Yes, sir.
Court settings and anything else, correct?
Yes, sir.
After he did not show up for the show cause setting, you ended up making 2 phone calls, is that correct?
Yes, sir.
To check and see if you were doing things the right way, is that correct?
Yes.
Who
Yes,
did who did you call first?
I believe Mr. Joseph Unruh or Unruh, I'm not sure how his name is pronounced. And
Where did he work at the time?
he worked for the commission for judicial conduct.
Okay. And that phone call took place on March the 9th, is that correct?
Yes, sir.
And that would have been the day after Mr. Kubosh failed to show up for the show cause hearing? Or actually,
No, it's a week later.
okay.
I waited a week just to see if we would hear from their office.
Okay, so I apologize about the time frame. March 1st was when he failed to show up, and then you issued the warrant, I guess, on the 8th. Is that correct?
Yes, sir.
Okay. And we know that he got that by fax on the 8th because a lawyer showed up at court, even though you were not there. Is that correct?
Yes, sir.
Okay. And so on the 9th, you called a lawyer for the Judicial Conduct Commission, and what did you tell him?
Well, I ran by him what I had done, what had happened and what I did to give notice. And I said, is there something I've left out or forgotten to do or didn't do or don't know to do, whatever.
And what was his response?
He told me that I had done everything I should and that sometimes you just have to take the action you have to take to get the attorney to come to court.
And why did you call the Judicial Conduct Commission to begin with?
I wanted to see because I had been told, and in fact, as recently as February 7th of this year, we were told by Ms. Habersham, but also told by other representatives of the commission, anytime you have a question or not sure about something, call the commission and talk to somebody.
Okay. Basically, though, I guess what I was trying to listen, you were trying to make sure you were doing things correct. Is that right?
Yes, sir.
And you made another phone call. Who was that to?
That was to Ryan Turner.
And who is that?
At the time, he was the general counsel for the Texas Municipal Courts Education Center.
Okay. And did you run the same scenario by him?
I did.
Okay. And did Mr. Unruh tell you that you needed to personally serve Mr. Kubosh with the show cause notice before issuing a warrant?
No, sir.
Okay. And so the second thing that they're charging you with is signing an order of contempt before the show cause was held, correct?
Yes, sir.
And so you did that only after he failed to show up at the show cause hearing, correct?
Yes, sir. I believe that's correct.
Making it final anyway.
Yes, sir. Making it final. Yes.
And you waited a week after that to see if anyone would show up before you issued the warrant, correct?
Yes, sir.
Did it?
Or even someone would call.
Okay. And do you believe that you could have issued a capias for him or any other lawyer for failing to appear at a hearing?
Yes, sir.
And why again did you issue? Let me back up. How did the logistics of that, how did that go down? Did you ask someone to help you? Is that in the computer system? Do you pull that up yourself? How do you do that?
No, I asked the clerk to prepare by running the form order that's in the encode system for an arrest warrant to be included with the notice to be sent to him.
Okay.
Mr. Kubosh, I mean.
And I also touched on in my opening, was the warrant, did you direct that the warrant be entered into the system at all?
No, sir.
And so what that means is technically there was a warrant, but if he had been pulled over, for instance, it would not have been in the system for an officer to be able to know about it, correct?
That is correct, sir.
Okay. And if he had, even after the warrant had been issued, if he had walked in and said, sorry, Judge, didn't show up the other day, I'll try to do better, what would you have done?
Withdrawn the whole thing.
And so 18 days later, instead, Mr. Pinnell showed up and he asked you to do a couple of things, correct?
Yes, sir.
Withdraw the warrant, which you did, correct?
Yes, sir.
Now, let's talk about that a little bit. That wasn't as seamless as everyone would have hoped. And the clerk has filed an affidavit with that. But long story short, she misplaced that in her desk and that didn't happen. You had to sign another order several weeks later, correct?
Yes, sir.
Okay. He also asked you to refer this to another judge to have a de novo trial on whether or not Mr. Kubosh was to be found in contempt, correct?
Yes, sir.
And you granted that motion, correct?
Yes, sir.
And so he got notice of a subsequent de novo hearing at which another judge was to hear the merits of this, at least in theory, correct?
Yes, sir.
And at that setting, which was, how far in the future was that? Do you recall?
I want to say May, maybe May 5th, something like that, I think.
6 or 8 weeks later, correct?
Yes, sir.
There was confusion about whether or not at that hearing, which entity was supposed to be prosecuting the contempt charge. Is that correct?
Yes, sir.
And Mr. Pinnell didn't even think that the lawyer that ultimately dismissed that case should be the one to make the call on that, correct?
Yes, sir.
But regardless, that person was allowed to sub in and dismiss the case, correct?
Yes, sir.
And there's a transcript that we included as part of the record, and I know you've read it, but at that hearing, Mr. Pinnell was even arguing that Mr. Kubosh, that not showing up to court was not even a contemptible offense, was he not?
I think so, sir. I don't remember exactly what all was said.
And the person that ended up dismissing the case argued, well, Judge, clearly not showing up to court's a contemptible offense, but regardless, we're dismissing the case, correct?
Yes, sir.
And did you have a problem with that at that time?
No, sir.
Why is that?
I felt we had spent so much time on it by then that it was just wasting assets and time and energy, and I didn't have any objection to it at that point.
Okay. Mr. Kubosh subsequently sued you for some form of damages civilly, correct?
Yes, sir.
Objection, relevance.
Judge, I think it's relevant to course of conduct here. And they've accused Mr. Judge Richter of having a vendetta. And so I think it's.
I don't know who he's referring to when he says they.
Well, you and Mr. Kubosh, I suppose, maybe not you, Mr. Graham, I apologize.
I'll allow one or two questions, but we're not going to go in depth in it.
That's correct. Thank you, Judge. He also tried to get you criminally prosecuted for this, didn't he, Judge Richter?
Yes, sir.
And that was denied as unmeritorious, correct?
Yes, sir.
Did you have any vendetta against Mr. Kubosh?
No, sir.
Was there ever any evidence of anything that could be interpreted as a vendetta against him by you?
No, sir.
Do you know him at all? Have you ever had any interaction with him?
I have never, sir. I've spoken to Mr. Kubosh one or two times, but I don't know Mr. Kubosh.
Would you have any reason to have a vendetta against him?
No, sir.
Were you issuing the contempt? Why did you issue the contempt order, both the first time it happened and this time?
I needed him to come to court to represent his clients.
Okay.
Or someone from his office, if not he.
Okay. And we've talked about this, but some of those issues that were occurring back in 2017 with his office has since been resolved. Is that correct?
Yes, sir.
Okay. So so when you issued the show cause hearing and just the contempt proceedings against him, did you have any ulterior motive other than trying to get his attention to show up for court?
No, sir.
Has any other court prior to this proceeding with the Judicial Conduct Commission, has any other entity, whether it be an appellate court or any other entity, ever instructed you that you were doing something improper regarding the procedures that you were engaging in for contempt?
No, sir.
Do you have anything else you would like special court review to know, Judge?
I don't think so.
Pass the witness, Your Honor.
Graham?
I have just a few questions. Let me start with this, Judge Richter. Do you still think that the way you handled these contempt proceedings, the two against Mr. Kubosh, the one against Mr. Taylor, is the proper way to handle contempt?
Except for the notice that I didn't have personally served? Yes, sir.
Well, let's follow up on that real quick. I mean, you've been an attorney for 50 years. Was it not your belief that you had to personally serve notice of contempt proceedings on people, even in the context of being a lawyer on the other side of a contempt case?
Not as I read the law, no, sir.
Okay. let's talk about the calls that you testified you made. And I want to make sure I'm right about the timing here. You issued the contempt and show cause order in Mr. Kubash's case on February 15th, 2018, correct?
Yes, sir, I believe that is correct. The warrant now, not the contempt order. The contempt order was issued previous to that.
Well, your initial show cause order and order of contempt were both dated February 15th, 2018, correct?
That's because it was the final order. Yes, sir, that is correct.
Okay.
I'm sorry.
That's
I have to say yes.
That's right. And the arrest warrant was issued March 8th, correct?
That is correct, sir.
And any calls that you made to anybody came after that, right?
Yes, sir.
So were you seeking guidance on how to handle those things, or were you seeking to find out if you had mishandled them?
I was seeking to find out if I had missed something, sir, that I should have done that I hadn't done.
In retrospect, do you think those calls would have been better placed earlier in the process?
In light of the information I got, no.
Did you tell Mr. Unruh that you issued a show cause order the same day that you issued a contempt order for Mr. Kubash to show cause for?
I believe I did. Yes, sir.
Okay. Let me ask you this. Let's go forward a little bit. I think Mr. Roark touched on this. Eventually, after the arrest warrant had been issued, Mr. Kubash appeared before you on a motion to vacate, correct?
No, Mr. Kubash never came, sir.
Well, someone representing Mr. Kubash appeared before you.
Mr. Pennell did, yes, sir, along with an associate of his.
Okay. And I understand you to say that at that time they requested that the contempt eventually be referred to an independent judge, correct?
That was my understanding that they were requesting that, yes, sir.
But you had a representative of Mr. Kubash in your court. You knew that you had their attention at that point, right?
Yes, sir.
Could you have withdrawn your contempt at that point?
Could I have? Yes, but I understood it needed to be referred to another court, to the administrative district judge,
But if
Susan
you
Brown.
weren't, I'm sorry, Judge, but if you weren't going to pursue the contempt, if you wanted to withdraw it, you don't think you could have just withdrawn it at that point?
I could, yes.
Okay. Your Honor, I think that's all I have. I'll pass. You're muted again, Chief Justice.
Any follow-up, Mr. Roark?
Very briefly, Your Honor. Judge Richter, in a direct contempt case, you're supposed to issue a order of contempt. Would you agree with that?
Yes, sir.
And so when you issued that order of contempt initially with the show cause hearing, you thought this was a direct contempt case. And so you thought you were supposed to issue an order of contempt, at least provisionally. Is that correct?
Yes, sir.
And when you sent both of those documents, and you'll see in them, he was to show up and show cause why that order of contempt shouldn't be final, correct?
Yes, sir.
And again, if he had just shown up and said, hey, I'll do better next time, the order of contempt would not have ever become final, correct?
Yes, sir.
And with regards to his question, neither Joseph Unruh or the other individual you referenced, if you had called them ahead of time, based on what information they gave you, they wouldn't have told you to do anything different than what you did anyway. Right?
Objection, speculative.
Sustain.
Okay. That's what you were trying to explain with your answer, though, to Mr. Graham, Judge Richter.
Yes, sir.
Pass the witness.
Any further questions?
That's all I have, Your Honor. Thank you.
All right. Thank you, Judge Richter. Your next witness, Mr. Graham?
Examiners call Mr. Paul Kubosh.
All right. You may proceed.
Thank you, Your Honor. Mr. Kubosh, you're an attorney licensed to practice law in the state of Texas.
That's correct.
How long have you been licensed?
Since 1993.
Okay. What's the nature of your practice generally?
Traffic ticket defense.
Okay. I want to, again, just with you, jump into this. You're familiar with the show cause and contempt orders and the arrest warrant that are at issue in the underlying complaint, correct?
That's correct.
When did you first see and or first become aware of the initial show cause and contempt orders that Judge Richter issued on February 15th, 2018?
I first became aware that I had a problem in Missouri City when the contract attorney that I had, who was covering my docket on March 8th, was informed by Judge Richter that an arrest warrant or something of that nature was going to occur, and that he talked to Mr. Pittsford about it. Mr. Pittsford let me know. And then when he let me know, that is when I knew something was wrong. And that's when I had Mr. De La Garza go down to court immediately to try to get the documents to find out just what was going on.
So you first became aware that there was any issue at all March 8th or later?
That's correct. Whatever day that Mr. Pittsford was there and Judge Richter had informed Mr. Pittsford that there was a problem.
It would have had to have been at least after the judge had issued the arrest warrant.
That's correct.
Okay. What would you have done if you had been aware of those issues prior to that?
Oh, I would have immediately went down to the court, contacted the court to try to deal with it.
Okay. And Mr. Roark made kind of a deal of this in his opening, but I mean, once you knew what was going on, you hopped too, right?
Immediately, I hired counsel to represent me and immediately dealt with it.
And that's what I was going to ask you next is what steps did you take to address those issues when you became aware of them? I
hired counsel to represent me to get to the bottom of what happened and to try to get a hearing on the contempt charge.
Okay. So you became aware that the arrest warrant was issued on or around March 8th, 2018, correct?
Correct.
What did you do with respect to that arrest warrant? You filed a motion to vacate?
Yeah, yes, we did. I had I hired the counsel, and first attorney who appeared down there was Levi Benton, and then I brought Mr. Pinnell on, and Mr. Pinnell, he had filed motions to vacate and to transfer to the regional presiding judge for an appointment.
Okay. So what was your feeling about the import of the arrest warrant when it was issued?
What do you mean by import?
Well, I mean, what did you think its effect was on you, if any?
Oh, there's no question I was subject to being arrested. Whether or not I immediately went to police officers who were friendly to see if they could run it on the system to see if they could find it. They could not find it, but that did not give me any comfort because so often here in Harris County and surrounding areas, police officers have what is, they call it pocket warrants, which is literally the warrant they keep in their pocket, because once the judge signs the warrant, as you know, everybody knows, it's an active warrant, whether or not it's on the computer or not. And so I was concerned that that warrant, that a police officer could show up with that warrant.
Okay. And so Mr. Pinnell went in on your behalf at some point in late March to try and get that order, that arrest warrant vacated, correct?
Correct.
And did Judge Richter sign an order at that time? Do you know?
I wasn't there, but apparently so.
Do you know if that order was filed at that time?
Apparently not, according to the information that's there.
Okay. So it took a while after that before the order vacating the arrest warrant actually got filed.
It took a motion to mandamus the filing of the order, and then the day before the hearing, they found it.
Do you know how long it was approximately between the time the arrest warrant was issued and the time that the order to vacate it was finally filed?
A couple of weeks, maybe 3, something like that. It was a while.
Was it in April?
It could have been.
Okay. Did you incur attorney's fees and other expenses in trying to address these matters?
With 2 motions to vacate, I sure did.
Okay. Your Honor, I think that's all I have for Mr. Kubosh right now.
Thank you, Mr. Rourke.
Thank you, Judge. Good morning, Mr. Kubosh.
Good morning.
Your practice is traffic tickets, and is it fair to say that's a volume practice?
Yes.
Okay. Do you know how many clients you have right now?
Right now pending.
Right, just ballpark.
I can't tell you without running on the computer how many I have pending, but prior to the pandemic, I would have 600, 700 a week.
Okay. And one of the motions that I read said that you'd handled hundreds of thousands of cases over the years. Is that correct?
Correct.
Okay. And so the point to all this is, and I'm a defense lawyer, so I appreciate the logistical complexities here, but that's a lot to keep up with, isn't it?
Yes.
Okay. And not only do you have cases in Missouri City, but you have them in Harris County and pretty much all the surrounding places around Harris County. Is that correct?
That's correct.
Okay. And so when I want to draw your attention to this particular client that this case is about, and I'm going to screw up his last name, but his name is Randy Dong, I think, D-U-O-N-G. Is that correct?
Yes.
Okay. When he hired you to represent him, he had already had one failure to appear, and warrants were already out for his arrest, correct?
Yes, that's correct.
And when you filed a letter of representation for his cases, and the case was set for a pretrial, is that correct?
Yes.
And for that,
And we posted bonds.
okay. And for either the first one or one of the settings, both the client and you or someone from your office failed to appear, correct?
I think that was before the letter of representation was filed, wasn't it?
It was actually after.
What day was it?
It was, I don't know the day, but it's actually included in the stipulations for the case.
Well, if you could tell me what day it was, I could answer the question. I'm not trying to be evasive.
Okay. I don't know. April 11th is what I'm told.
April 11th of
2017, I believe.
And when did I file my letter of representation?
You know that date? I don't know that date, but it's in the stipulations.
Well, then if you can tell me, I can answer the question.
Okay. March 7th.
Okay, well then that would be correct.
Okay. And so the point I'm making is there was already a failure to appear by your office in this case, correct?
Well, there was, you mean for the client?
Right.
Yeah, the client did not appear.
Right. And well, just to be clear, the client didn't appear and had warrants for his arrest. He then hires you those warrants get withdrawn, and then for a subsequent hearing,
The
you
client did
and the
not-
client.
Yeah, the
held to
client,
appear.
Excuse me, one at a time.
I'm sorry. You're correct. The client did not appear.
And neither did anyone from your office, correct?
That's correct.
Okay. And so warrants were issued again for your client, correct?
Correct.
And y'all had to post a cash bond for those, correct?
Correct.
And this particular trial setting was a preferential setting for the 15th of February that was actually set back in October, correct?
It was not preferential. There were other jury trial settings set for that day.
Okay. And when you get notices from Missouri City, normally, do they come by fax?
Normally they come by fax, and I've known Mr. Richter for a long time, and Missouri City recently went to fax, but not all courts do fax. Some still mail, but his is from fax.
Okay. When you said they recently went to fax, they've been doing fax with your office at least for the past 5 or 6 years, though, correct?
I don't know the time frame, but I'm thinking over a 25-year practice of law. So over the last few years, I would call it recent. Matter of interpretation of what recent means.
Okay, fair enough. And so the day before, well, let me back up. When you get notices in Missouri City, the notice for a court setting, or at least for a jury trial in this particular case, those say that motions for continuance should be made 8 days prior to the setting. Is that correct?
That's correct.
And in this particular case, your office filed a motion signed by you the day before asking for a continuance. Is that correct?
I filed it as soon as I knew I had a problem when Katie had gotten the flu. So I filed it immediately, which was clearly within the 8-day deadline, because I felt like I had an obligation to file the motion anyway, since I knew I had a problem. So that would be yes.
Your motion, though, didn't mention the flu, did it?
No, it didn't mention the flu because I hadn't physically seen the records. And since it was going to be a verified motion for continuance, I didn't want to swear to it because I knew that this was going to be a very tenuous situation. So until I actually viewed the records, I wasn't going to swear to something that was hearsay. So that's why I did not put that. Instead, I relied on Rule 13 of the Regional Rules of Administration, conflicting engagements of attorneys.
Okay. And so the motion said, paraphrasing, have too many courts and too few lawyers. Is that correct?
That's right, because as I knew the courts were aware, and the presiding judge used to be a sitting judge in the city of Houston, and I know Judge Richter as a prosecutor in many of the other jurisdictions around the Harris County. They knew that the jury trial settings in the city of Houston were also set, and they knew the situation. So I could have wrote it better, and the result would have probably still been the same, but I was trying to rely on Rule 13, conflicting engagements of attorneys.
Okay. And those motions were all faxed, weren't they not?
They were faxed.
And another judge heard that motion and denied it.
It was presiding Judge Sinclair, who used to be the judge of the city of Houston.
Okay. And so she was the one that denied that motion, not Judge Richter, though, correct?
Correct.
And so you subsequently turned in some records about the flu, but that was not done until after the court setting had gone by, correct?
That is correct.
Okay. And so for the 15th, with the jury trial setting with that client, no one from your office showed up, right?
Correct.
Okay. And you've seen the show cause notice that was sent over on the 15th, correct?
Yes,
And you've seen the fax confirmation page, correct?
yes,
And the fax confirmation page has says Kubosh on it, indicating that your office had received it, correct?
correct.
And are you saying that, I just want to be clear about your position. Are you claiming that your office didn't actually receive it, or that you just didn't see it with your eyes?
I did not see it with my eyes. It did not come to my attention.
Okay, fair enough.
Is the position.
Okay. And the notice of warrant, you said that the first time that this was brought to your attention that you had a problem, quote unquote, was when another lawyer had told you that Judge Richter had verbally told him about this situation, correct?
When my contract attorney, Robert Pittsford, was informed by Judge Richter that that there was a problem, talking about an arrest warrant in open court in front of a lot of clients, about how I don't show up to court, and that's when Mr. Pittsford let me know at the end of the court that I'd have a problem.
Okay, so are you saying that you did not did you see the fax notice that said, hey, there's a warrant out for your arrest?
I did not see as to at what time did I see the fax notice.
At any time, but did you see it come in on the 8th?
No, I did not.
Okay. The lawyer that went down there on the 8th, Roberto de la Garza.
Okay, I don't know exactly what the date was. Let's with Mr. Pittsford, that was in court. And so I knew I had a problem on the day that Judge Richter had informed Mr. Pittsford that there was a problem.
Okay.
So I knew that the procedure would have been, we would have called the court to find out what's going on. They probably would have told us that there was an arrest warrant. So then I would have sent Mr. De La Garza down there to try to get documents from them. So it wasn't until Mr. De La Garza went down there to get the documents from them that I actually saw them.
Okay.
If they gave them to him, and I think they did. I'm trying to remember when I first saw the warrants.
But you don't, I'm just trying to get clear, the arrest warrant that was faxed to your office, do you think you received that the day that it was sent to your office on the 8th of March?
I'm assuming the arrest warrant has a fax confirmation page, so I can only assume that it was in paper in a fax that we received. I just didn't get it, and my office manager didn't get it. As far as see it, it may have been here with the paperwork somewhere in somebody else's file. I don't know, but we were not aware of it.
The reason I asked that is, and I can't put this up on the screen, but it's in the exhibits. Mr. De La Garza went down there and filed some handwritten motions. And I appreciated these handwritten motions because I've had to do that myself in the municipal court before. But the very first thing he mentions on here is in Roman numeral 1, the defendant was notified via fax on March 8th, 2018 of an open arrest warrant.
Yeah, exactly. Because it's like I had just said, our procedure would have been to have called, and if we and that's when I knew I had a problem, because after Mr. Pittsford was notified by Judge Richter that there was a problem, we did a deep dive into it. So then after that notification, we would have called the court. We'd have got all that information, because I wasn't going to sit around and just wait. I didn't send Mr. De La Garza down there for no reason. We had to get as much facts as we could so he could know what he's looking for.
Okay. Do you think it's appropriate for a lawyer to be found in contempt for not showing up for court?
It all depends on why he didn't show.
Okay.
But if he's appearing in another court in a jury trial setting, I think that would be a legally incorrect holding, because if you're in a jury trial setting with older cases than the one that you're set for in another court, then, again, I look to the, Rule 13 for guidance. So you appear at the court that has the older settings first.
And I agree with that, but it's not improper to, those inquiries are not improper, are they, to ask those questions about where were you and were there older cases and those kind of things? I mean, that's a proper inquiry for someone to make, correct?
Oh, absolutely.
Okay.
But those were never made.
Well, they were attempted to be made.
Well, I'm not aware of any attempt to make. If you could refresh my memory, I'd like to.
Well, he said a show cause hearing for you to come in and explain that, did he not?
I did not get service of that.
Well,
So I couldn't have gone.
but I'm saying he set one, you got fax notice of it, you got fax notice of the warrant, which it's the first thing that the lawyer sent down there mentioned via fax. But in any event.
Maybe it's like the misplacing of the warrant.
Well, there's fax confirmation for this
I'm
one.
talking about the.
Excuse me, one at a time. I can't get this, Judge.
Sorry.
Gentlemen,
Maybe it's like the misplacing of the motion to vacate in Missouri City that was misplaced in the desk.
You're saying it was misplaced in your office?
Oh, well, clearly I didn't get it. That's a problem on my side, and I did not get it across my desk. That's
Okay.
a problem on my side.
Okay, thank you. Fair enough. You got notified of the warrant on the 8th of March, and it was 18 days later before someone showed up with a motion to get that withdrawn, correct?
If that's what the record shows.
Okay.
But if you're making reference to the 18 days, that's how long it would have been till Judge Richter would have had a hearing that Mr. Pinnell could have shown up to. We would have been there on the next day for a motion to vacate. But Judge Richter is a part-time judge there. I don't think he works full-time. He's got other obligations. So that's the earliest hearing we could get.
Okay. And would you agree with Judge Richter's assessment of his interactions with you over the years?
No, that's totally incorrect.
He's had more interactions with you?
Absolutely.
Okay.
Would you like me to enumerate?
No, but Mr. Graham can ask you, I guess, if he wants to.
My first jury trial was with Judge Richter when he was a prosecutor in Bel Air.
Oh, okay.
1994.
Y'all go way back, it sounds like.
We went very long.
Okay. Your first jury trial?
My first jury trial as a practicing attorney in 1994, City of Bel Air, Judge Richter, well, he's still the prosecutor in Bel Air, was against him.
Okay.
You remember your first one?
Did you win or lose?
I lost, but I had some bad facts.
You can't control your facts. So I think I won my first one, but I was a prosecutor, so I had the facts on my side. Do you know if someone fails to show up for court, is that direct contempt or indirect contempt?
Depending on the circumstance, if they actually do something that is legally contemptible, like they're playing golf or something, then that would be indirect contempt.
Okay.
Judge Richter, as a prosecutor, has a lot of is very familiar with the contempt rules from the other jurisdictions.
No further questions, Your Honor.
Thank you. Mr. Graham?
Just a couple. How long have you been licensed again, Mr. Kubosh?
Since 1993.
So going on 30 years.
Correct.
When your clients are subject to contempt proceedings, do you think it's important that due process is accorded to them as afforded by statute and common law?
It's extremely important. It's our craft. It's the only guarantee that we have to have a hearing that a right will be protected, the right to be heard.
Do you think it's important for the judge who's engaging contempt proceedings to know whether or not due process should be accorded and how it should be accorded to clients, litigants, or officers of the court?
Absolutely. But especially whenever somebody's personal freedoms are attached to your your knowledge or lack thereof.
That's all I have, Your Honor.
Mr. Rourke?
I don't have anything else, Judge.
All right, thank you, gentlemen. And I'm assuming based on your representations, there are no further witnesses?
None for examiners, Your Honor.
Not for Judge Richter, Your Honor.
All right, closing, Mr. Graham?
You bet. Thank you again, Chief Justice Rodriguez. Thank you, Your Honors. May it please the court. The evidence that's been stipulated to here and that we've heard today meets the preponderance standard that this court will apply. Judge Richter failed to accord Paul Kubosh the most basic due process protections that accompany contempt proceedings brought against an officer of the court. Then, having done that, he issued an improper arrest warrant against Mr. Kubosh that hung over his head for over a month before it was finally vacated by the filing of an order. And I want to make a quick comment about this notion that it's just legal error. Curing lack of notice on a legal error in the civil or criminal setting is different than what we're discussing here today. We're discussing the ethical standards that the Texas judiciary needs to hold itself to. In this case, on these facts, Judge Richter did some things that are demonstrably improper. And he needs to understand, the judiciary needs to understand, and the public needs to have confidence that upholding the highest ethical standards of judicial conduct does today and will always include affording all those who come before the court the full measure of due process, especially in matters of contempt, one of the most powerful tools at a court's disposal. Certainly one of the most powerful tools at the disposal of a fine-only court. Examiners respectfully submit that after reviewing the facts and the evidence stipulated to and presented here today, along with the applicable ethical standards to which Judge Richter and all Texas judges must be held, this panel will agree that Judge Richter's actions in the underlying contempt matter are worthy of at least a public admonition and an order of additional education regarding the proper use of contempt. If we're not going to say that according due process to folks in contempt proceedings is a matter at least for ethical consideration, I'm not sure what is. That's all I have. I thank you again for your time. I thank the witnesses and Judge Richter for your time. Thank you.
Thank you. Mr. Rourke?
Your Honors, I would submit that the commission has not really come close to proving their case. Simple errors are not enough to be sanctioned. They're just not. If they were, then every time a case was appealed and you found error from an underlying court, that would be a sanctionable event. And we know that's not the law. What they have not talked at all about was even the concepts that they included in their stipulations about what the law to be regarding bad faith and how egregious an error must be. So let's go over this. And I'll reference this in our subsequent brief, but there's a case by the Court of Criminal Appeals en banc, ex parte Murphy, where another judge held someone in contempt for not showing up for court. And first of all, he called it a direct contempt instead of an indirect contempt. And he denied the guy hearing entirely and had him arrested and then released, which were all screw ups, errors in our parlance that we're talking about here today. And the Court of Criminal Appeals, but subsequent to that, of course, it was assigned to another judge, and that judge ended up finding that person in contempt. And what the court said was, while we agree that the offended judge deprived applicant of due process by holding him in constructive attempt without adequate notice of a hearing, the subsequent de novo hearing provided adequate constitutional due process safeguards, thereby curing the prior violations. The notice to appear and show cause delivered to applicant a full 5 days prior to the de novo hearing was sufficiently specific to afford complete notice of the allegations. And as such, this negated any harm caused by the failure of the offended judge to extend adequate notice and hearing. And that was a case where the judge literally said some version of, I don't want to hear what you have to say about this, and just found him in contempt. Now, if that kind of egregious error, or what you would consider at least more egregious than this in this particular case, didn't even prevent that individual from being found in contempt, and any harm was negated by the subsequent hearing, how on this set of facts could you ever find that the technical errors that Judge Richter made that resulted in no harm could be sanctionable? These are common errors that in all other cases are actually negated by the subsequent de novo hearing. How could something that can be cured ever be sanctionable? Furthermore, and as importantly, there's a case that I'll cite in subsequent. It hasn't been released for publication, but I'm going to go through it just because it explains it well. It's the Ginberg case, which I'm sure Mr. Graham is familiar with. But they do a very good explanation of just describing what kind of errors rise to sanctionable conduct. And they say, in judicial misconduct cases, the word willful generally means the improper or wrongful use of the power of a judge's office by acting intentionally or with gross indifference to his conduct. And it says a judge acts intentionally when the act is done with conscious objective of causing the result or acting in the manner defined by the pertinent rule. And this was cited in the stipulations. If a judge intentionally engages in the conduct that violated judicial canon, then the violation was willful. In this case, very much like in the present case, says the commission focuses on this last statement and urges us to hold that if a judge intended to engage in the conduct for which the judge is disciplined, then the judge's conduct was willful. But the cases where that particular thing is cited, that if the judge intended to do it, it's willful, they all cite cases talking about something other than legal error. something outside of the context of trying to figure out what's right in that particular case, such as a judge making a improper phone call and trying to inure the benefit of the judge's stature as a judge to get another official to do something. We had a recent case in Travis County where the judge of the commissioner's court was found guilty of a sanction for wearing a funny hat at a commission meeting. And that would certainly be a context in which the conduct she engaged in was willful, but that should not be applied to the legal error context. And it goes on to say, this standard does sometimes appear in published cases involving both legal and non-legal error, but is almost uniformly applied to non-legal error cases. And they go on to point out the obvious, which is when you're talking about legal error cases, every ruling that a judge makes is intentional. And so by that standard, if they make a wrong ruling, everything would be intentional. And if the standard is, if they intend to make it, then it's willful, then every error they made would be sanctionable. Every case that you guys hear as appellate judges in the normal course of your business, if you rule that a judge made an error in the law, that's a sanctionable event. That cannot be the rule. And so they went on to say, it has long been established that charges involving no more than mistakes of judgment honestly arrived at or the mere erroneous exercise of discretionary power do not constitute judicial misconduct, which is exactly what we have here. Errors made honestly and with great effort to try to figure out if he's doing something wrong. There ought to be some type of estoppel argument. If you call the Judicial Conduct Commission and ask them if I'm screwing this up and they tell you no, they shouldn't be able to then sanction you for that conduct. That's exactly what we have here. We'll probably never have another case like this, where a judge actually calls the Judicial Conduct Commission saying, hey, am I screwing this up? Lawyer tells you no, and then you subsequently get sanctioned. From where I'm from back in East Texas, we had a rule that is called the taint fair rule. Well, that taint fair on that. If I call the Judicial Conduct Commission and say, am I doing this right? And they tell me yes, I don't think you ought to be able to be sanctioned by them subsequent to that. In any event, the rules they establish are, was the conduct egregious, meaning whether was it extremely or remarkably bad, flagrant, or shocking? None of the things he did would fall in that category. If you look at all the cases for these types of issues, particularly contempt, there are judges doing far worse things than issuing an arrest warrant instead of a capias that never gets put in the system. The other issues are whether the error was part of a pattern or practice. There's no evidence that it was in this case. What Mr. Graham keeps bringing up is that the judge issued a show cause and a contempt order at the same time. The contempt order was clearly not final at that time, and it was contingent on the show cause hearing. I don't even know if that's error at all, quite frankly. Was the error made in bad faith, and otherwise was there an ulterior motive? Clearly not. Mr. Kubosh had all the opportunity today and in previous legal filings suing Judge Richter and trying to get him prosecuted to say what the ulterior motive was or what the source of the vendetta was, and he came up with zero. There is zero evidence that there was an ulterior motive here other than Judge Richter trying to get Mr. Kubosh or his office to show up for his client, which in this very case, his office had already failed to do once, resulting in warrants for Mr. Kubosh's client. How much worse could that be? Your client, before he arrests you, fails to show up for court. He hires you so this doesn't happen again. And the very first setting after that, your office fails to show up for court. It's not crazy to think and wonder why Judge Richter in the municipal court there in Missouri City would want to get Mr. Kubosh's attention. And that arrest warrant did get his attention. And let's face it, there is great skepticism, I think there was in Missouri City, and there should be on this court, on whether Kubosh's office received those faxes. The fax with the warrant is the very first thing, and I'll point this out in the subsequent briefs, that the lawyer that he sent down there cited as to why he's showing up on the 8th. It says the defendant was notified via fax on March 8th of an arrest warrant. Well, that got Mr. Kubosh's attention. And what he did when he found that out was send a lawyer down there to figure out what was going on. So yeah, you get a motion for continuance where you say, we don't have enough lawyers to come to court tomorrow. You don't say anything about having the flu or anything like that. And then you get a fax notice, which was the way that they did everything with Mr. Kubosh's office with a show cause. He doesn't show up for that. What's a judge supposed to do? None of this is patently unreasonable. All of the technical errors that he made were cured. There was flat out no harm to Mr. Kubosh at all by this process. And he subsequently could have been found in contempt. He wasn't. Why? Because Judge Richter did not have an ulterior motive, and he finally decided, along with Missouri City, this has gone on far enough. If there was any bit of a vendetta, it's suing a judge after this and trying to get them criminally prosecuted for simply trying to get you to do what you're hired to do in the first place, which is show up for your clients. Judge Richter has certainly been through enough as part of this process. We all have, but at the end of the day, the commission did not prove what they needed to, in particular, bad faith, or that these technical errors were egregious enough to be a sanctionable violation, and we ask that you find that they are not.
Or Mr. Graham, if you'd like, I can give you a 10-minute rebuttal. You carry the burden, and so I don't want to deprive you of that last opportunity to say something.
I appreciate that, Chief Justice Rodriguez. I think everything else that the commission needs to say, we will say in our briefing.
All right. Thank you, gentlemen. You've given us a tough job. We look forward to your post-trial briefings and your attendance this morning. And we'll just continue on with the orders that are already in place in terms of the timelines, and hopefully get this matter resolved as quickly as allowable. But thank you all again for everybody's participation this morning. And at this time, with the exception of my sisters on the bench, I'll ask everybody to excuse themselves.
Now, counsel,
Oh,
I mean,
sorry.
Judge, I would like to ask a few questions if I may.
Yeah, forgot about that. Thank you.
Okay, I apologize. Well, I just have a couple of questions for Mr. Graham.
Yes, Justice.
I guess since you carry the burden. Thank you very much for your professionalism, all of you. And this is my first opportunity to serve in a special court. And so I'm taking this matter very seriously and have done every effort to review all your documents that have been provided so far, and will certainly read any post submissions as carefully as I have your other documents that have been filed. I guess the question I have is for Mr. Graham. The questions I have is the commission stating or believe that there's any evidence or contention that Judge Richter's misapplication of the law was in bad faith or that he intentionally failed to follow the law?
I think, Your Honor, my response to that is that what we're going to show in our briefing is that the case law on this issue is that, and I'm going to quote from a case called In Re Bar. You'll see it in our briefing. It's been.
I've read the case, Counselor. Go ahead.
I think importantly, what Barr says is that with respect to judicial disciplinary proceedings, a specific intent to use the power of the judicial office to accomplish a purpose which the judge knew or should have known was beyond the legitimate exercise of judicial authority constitutes bad faith as a matter of law. And I think, what the commission's position is that when a judge chooses to exercise contempt powers in a way that he knows or should know is improper by missing important parts of the due process that's accorded there, that he or she has done something which he knew or should have known was beyond the legitimate exercise of judicial authority.
Okay, but counsel, wouldn't you agree that every legal, ruling is intentional? Therefore, wouldn't you agree that the ruling, that we have to find some willful violation, that it's just not enough to show that it was intentional, it has to be willful. And the case law, also the Barr case says egregious or done in bad faith. Wouldn't you agree that is the test that has been developed to determine whether the rulings are legal rulings as opposed to other misconduct would be subjected to disciplinary proceedings?
Well, I think that another thing that's said in the case law, and this is the In Re Toma case, is that the term willful requires a showing, but not necessarily a finding of bad faith in that context. And I think that there is a distinction to be made between whether or not the judge has accorded due process to someone and whether or not he or she has made a legal error, say in deciding that contempt was, in making the ultimate decision that contempt was applicable in a given case. I think it's a substantively, quantitatively different thing to say that a judge's potentially incorrect decision on whether or not contempt was applicable is to be treated the same as whether or not due process protections are to be afforded to them, at least in the ethical process.
Now, is there any evidence, at least that you are putting forth, that would be an evidence of an ulterior motive that would support a conclusion that Judge Richter's legal errors were in bad faith?
I think setting aside for the moment the question of whether or not bad faith can be demonstrated by having chosen to do something that he knew or should have known was outside of his authority. I think, for instance, if you look at the arrest warrant that was issued, and you see that it says it's accompanied by a sworn affidavit. To a person reading that arrest warrant, that says something different than what actually occurred in this situation. And I think one could infer from that, potentially, some amount of motivation on the part of the person issuing that arrest warrant, amongst maybe some other things.
Thank you, Counselor. I appreciate
You bet, Justice. Thank you. Good question.
And the way I understand the reading of the cases is as Mr. Rourke outlined, it is, appellate court's purpose is to review underlying courts, and trial judges make errors. Appellate judges probably make errors. But so I understand that. And I think that the cases really make the distinction that obviously, as Mr. Rourke already pointed out, that, obviously if they make a particular ruling or issue an order, it's willful in that it's intended. The question becomes when you're looking at a legal error, I think is more about, it can be on the basis of bad faith, but also gross incompetence in which a judge knew or should have known, that demonstrates almost an indifference, an egregious kind of indifference to the law, that it kind of reminds me of criminally negligent homicide, in which we've decided, or y'all have decided in this case, and then we're going to look at the case law, that if that error is so egregious that it rises to the level of being unethical. Is that understanding correct, Mr. Graham?
Excuse me. I think you're understanding it correct, Chief Justice Rodriguez. The one thing I'll say is that, I'm not sure that what we're talking about in this case is solely just an issue of what these cases talk about when they're talking about mere legal errors. And I want to make a distinction real quick. You all know this, but when we're talking about courts of appeals sitting in civil cases or criminal cases and reviewing what's happened below them and determining whether or not there's harmless error or error that could have been cured, we're talking about something that's completely different from what we're talking about in the ethical disciplinary proceeding process. We're trying to determine what standards is the judiciary going to hold itself to, because we're the only ones who can create those standards and meet them. And the commission's position is, in this case, and certainly generally, that when a judge fails to accord clear due process rights to a litigant, a citizen, a witness, an officer of the court, that's a problem that needs to be addressed. And I'm not sure that it's, strictly speaking, just a legal error if we've determined that he or she didn't afford those protections. We have a canon specifically related to according due process of law to people, Canon 3B8, which is cited in our charges, that talks about, I think, if a judge fails to accord process of law as required, that is sanctionable. The Supreme Court has told us in the rules it's sanctionable. Does that mean that if they don't, we call it just a mere legal error to get around Rule 3B8? I don't think that's what it means. So I think there has to be a qualitative, a quantitative difference between those sorts of issues. And maybe this is a case that helps point them out. I will point out in our briefing a prior court of review, at least one prior court of review case in a similar context where a similar sanction was issued and affirmed. And I will also point out many similar sanctions that have been issued by the commission in the past and not appealed. So I say that to let you know that that's how the commission views the application of the code to this sort of action, these sorts of actions. And I think it's maybe not a black and white question, an easy question to answer, but I think that at the end of the day, this court needs to decide, is the due process that's clearly afforded in contempt proceedings and clearly afforded in contempt proceedings related to alleged attorney contemners, officer of the court contemners, if that's not afforded, is that an ethical problem for the judiciary? And the commission thinks it is, and I think the court will agree that it is.
Mr. Graham, can I follow that up? So are you sort of taking the position, or the commission trying to now create a new category of disciplinary standard for not affording due process? So are you saying this is a case of first impression for us now, in that the commission is now sort of trying to create this new category?
I don't think so, not at all, Justice Hinojosa, and it is and can be confusing. I will say that when you look at courts of review, that sometimes they address issues like this with reference to this egregious legal error analysis, and sometimes they don't, even in circumstances where it seems like they're analogous or exactly the same. And it's not always altogether clear, how courts of review have tried to approach it. What I can tell you is that the commission always approaches questions related to what I'll call abrogation of due process, for lack of a better term, always views those as things that need to be addressed from an ethical standpoint. And I will leave it to the good judgment of this court to determine if this is one of those cases.
Thank you.
Any further questions? No?
I don't.
All right. With that, we will recess and anxiously await what y'all are going to submit to us in the next weeks to come, and appreciate your participation again this morning. We appreciate it. Thank you.
Thank you very much, Your Honor.
Thank you, Judge.
You're welcome.
Bye-bye.
Bye.